Good evening and welcome to this regular meeting of the Council of the Municipality of North Perth. Our meeting date is Monday, November 17th, 2025. I'm Mayor Todd Kasenberg and I'll call this meeting to order. I ask the clerk to note our starting time for the minutes is 7 p.m. A warm welcome and greetings are extended to councillors, staff, delegations, and observers who will participate in this meeting, regardless of whether they are physically in attendance in the council chamber, in Listowel, or being connected through web technologies. We begin tonight's meeting with the playing of O Canada. Those in chambers, as able, are invited to stand. We acknowledge that we are on the traditional land of the Anishinaabe peoples. We wish to recognize the long history of Indigenous peoples in Canada and show our respect to them today. We recognize their stewardship of the land. May we all live with respect on this land and live in peace and friendship. Tonight's meeting is being streamed live on the Municipality of North Perth YouTube channel and will be available there after this meeting as an archived video. To those viewing this meeting via the YouTube channel, a warm welcome to you. To those present in the gallery today by attending a public meeting of the Council, you are consenting to your image, voice, and comments being recorded. Anyone who is invited to speak will be recorded, and their voice, image, and comments will form part of the live stream. The chair and/or the clerk have the discretion and authority at any time to direct the termination or interruption of live streaming. Such direction will only be given in exceptional circumstances when deemed relevant. Circumstances may include instances where the content of debate is considered misleading, defamatory, or potentially inappropriate to be published. Attendees are advised that they may be subject to legal action if their actions result in inappropriate and/or unacceptable behavior and/or comments. Thank you. At this time, I invite your decorum over the course of the coming meeting. I have regrets tonight from Councillor Sarah Blazek. I'm going to use my discretion because of late-breaking circumstances related to adjusting the agenda to defer our conflict of interest statements to follow the approval of an amended agenda tonight. So let's move first to a resolution related to our agenda. There isn't a revised agenda proposed tonight. I'm going to call on the clerk to explain what has been updated. Clerk Carter.
Thank you, Mayor Kasenberg. Through you, tonight we are recommending that the agenda for tonight's meeting be approved as amended to include item 8.4, a delegation from Heather Bentley and Carol Barber regarding agenda items 9.4.2 and 12.4, and item 8.5, which is a delegation from Bert Johnson regarding agenda items 9.4.2 and 12.4.
Thank you, Clerk Carter. So let's put the resolution for consideration forward as follows: that the agenda for tonight's meeting be approved as amended to include item 8.4, a delegation from Heather Bentley and Carol Barber regarding agenda items 9.4.2 and 12.4, and item 8.5, a delegation from Bert Johnson regarding agenda items 9.4.2 and 12.4. Moved by Deputy Mayor Kellum, seconded by Councillor Anstett. Any discussion or debate on this? Seeing none, let's have that vote. And that is carried. Thank you. All right, we're going to roll back now then to general announcements, especially with respect to pecuniary interest. So, members of council have full lives of engagement in the community. Sometimes they may find themselves with a potential financial or pecuniary interest in an item at the council table. Provincial legislation mandates councillors to declare this interest, and in so doing, avoid direct involvement in the consideration or voting on the item. I invite all councillors with a perceived pecuniary interest, including those who have already so declared in writing, to verbally advise the chair in public session. Documentation is to be submitted, if not already done, pursuant to council procedures. Councillors may declare now or at any point in the meeting should such interest be recognized. Colleagues, who amongst you would like to make a declaration tonight? Deputy Mayor Kellum.
Yes, and thank you. Through you, Mayor Kaysenberg, I will declare pecuniary interest on the following items: 8.4, 8.5, 9.4.2, 12.4, and the confirmatory bylaws 17.1, as my mother and father-in-law are tenants of Perth Meadows. Thank you.
Thank you, Deputy Mayor. Councillor Rothwell.
Good evening, Mayor Todd, members of council, staff, and public. I too would like to declare similarly on item 8.4, 8.5, 9.4.2, 12.4, as well as the confirmatory bylaw 17.1. I'm a volunteer with the United Housing Campaign Committee. Thank you.
Thank you, Councillor Rothwell. And I too will make a declaration, exactly the same magic numbers: 8.4, 8.5, 9.42, 12.4, and 17.1 tonight. And that is by reason of employment with United Way, Perth, Huron. Anyone else? I'm not seeing any others. So, as chair of this meeting, I'll manage the flow of proceedings tonight and largely in accord with our agenda and rules of procedure. Some may be participating remotely by web conference. Should they wish to speak, they can draw the attention of the clerk to this using the conferencing technology's text chat function. If technical difficulties arise for remote participants, we will advise and try to support with help from our IT person on duty. Let us now focus on the people's business. Part of that focus is best achieved when those in the chamber silence and put away their phones. That brings us to item 7 on our agenda, the so-called consent agenda. Consent items are placed on our agenda because they're believed to be non-contentious, yet they may warrant council's recognition and/or action. Grouping them expedites our business. However, any councillor wishing to extract an item from the consent agenda for discussion, debate, and individual action may do so. There are 17 items on our consent agenda tonight, including the minutes of our last regular council meeting. Colleagues, anything to extract here or any corrections you'd like seen made to the minutes? Councillor Johnston.
Good evening, thank you. I just had a question about 7.10.
7.10, thank you. Councillor Duncan.
I'd like to speak to 7.10 as well.
Okay, 7.10 is earning some attention tonight. Anyone else? All right, let's start with Councillor Johnston.
My question was going to be to Councillor Duncan, if he can speak to 7.10 about how it's going to affect Maitland Valley Conservation with the reorganizing of the conservation authorities. So that's quite simple.
Thank you. I think he, it sounds like he planned it perhaps. Councillor Duncan, you're on.
Thank you, through your mayor. Yes, I'm sure we've all heard that the province has decided to restructure conservation authorities from 36 down to 7, and in my opinion, it's a kind of a poor move, but right now they're requesting comments. So through discussions with the mayor, I was wondering if council would like to form a small working group with staff to analyze the situation and create some comments. Some of the facts are that municipalities provide 50% of the funding to conservation authorities. The province has provided no ideas in costing of these amalgamations or the umbrella organization which they propose to create to manage it. They, their contribution is about 6 to 8% right now currently to conservation authorities. So they don't provide much funding. We provide the bulk of the funding. So I think it's very important for us to provide comments on this. Their proposal right now would encompass 78 municipalities and roughly 1,400 kilometers in one authority that we'd be part of. I don't know how we'd ever have a board meeting with municipalities, 78 of them all sitting around the table. So I guess that's my proposal, and I guess council can do as they wish with that.
All right, thank you, Councillor Duncan. Indeed, I think the resolution is that this council supports the creation of an ad hoc study group to be composed of representatives of council and staff, or supported by a staff member at the very least, to study and prepare comments regarding the proposed changes in the regulations, I believe it's regulations, right, for conservation authorities and the establishment of conservation, a new conservation super authority. I've forgotten the name they've used, but does that sound, does that capture it? Clerk Carter, anything you heard in that didn't make any sense? All right, anything, CAO Snell, anything you want to add to this? You would feel comfortable finding a staff member who could work with some members of council on this who are interested? All right, thank you. So moved by Councillor Duncan, seconded by Councillor Rothwell. Thank you. Any discussion or debate? Colleagues, you realize that this will require some of us to actually do this. I'm hoping that some of you will feel inclined to volunteer and add your voice to this. I'm not seeing any discussion or debate. Deputy Clerk, you ready with us? All right, let's have a vote on this one then. And that is carried. Thank you. I think it's courtesy at this point if I can get an expression of interest from councillors who might be willing to participate in this. So Councillor Duncan, Councillor Rothwell, and certainly I'm interested as well.
How long is the period open?
It's December 10th?
22nd.
22nd of December. It's coming up. Yeah. Okay. So we have it noted, and colleagues, if others of you have second thoughts and wish to join the fun, you're welcome to do so in the near future. Let us know. All right, anything else from the consent agenda for specific discussion before we consider the omnibus resolution for this? I'm not seeing it, so let's consider the general resolution as follows at consent item 7.1 to 7.17. Be received for information, and the minutes of the November 3rd, 2025 regular council meeting and the November 10th, 2025 special council meeting be adopted. Moved by Councillor Nordum. I think I saw your pen wave. Thank you. Seconded by Councillor Johnston. Any discussion or debate? Seeing none, all those in favor through the machine here, let's not do it manually, let's have a vote. And that is carried. Thank you, colleagues. All right, at this time it's proposed we move on to agenda item number 8. We have no public meetings warranting a recess from council at this time. We will now receive delegations from those with interest in our council's business or authority, specifically addressing matters that are on tonight's agenda. I remind the delegations generally that in accordance with this council's procedural bylaw and without a special dispensation from council, a total time of 10 minutes of presentation is permitted, following which I will, with duration at my discretion, provide an opportunity for councilors to ask questions. Delegation is to present on the topic declared on the submitted request for delegation forms, and deviations from the topics are not acceptable to the chair or to this council. Decorum is required. Further to my usual request that we maintain an atmosphere of respect and courtesy, I remind those delegating that they should not use the names of those who have not consented to such use. First, tonight, we will hear for item 8.1 from Tyler Sager, Manager of Legislative Services and Clerk of Perth County, Marvin Smith, Perth County Forestry Inspector, and Daryl, and your last name is a challenge to me, Harlock, something like that. Thank you. A prosecutor every once in a while. You know how many years I've heard my name used wrong. Prosecutor for Perth County who wish to speak regarding an update to the Perth County forestry bylaw that is pending. Gentlemen, at your discretion, and Mr. Sager, call those who you need.
Thank you. So through the mayor, hello council, and thank you for having us here today. I'm Tyler Sager, the county clerk. With me is Marvin Smith, the forestry inspector, and Daryl Howerlick, who is the prosecutor. We're presenting an update on Perth County's Forest Conservation Bylaw 3836, 2021. This is a review process, and we're gathering feedback on the proposed bylaw. So this is part of our lower tier consultation roadshow as directed by county council. Now perfect, excellent. So let me start with some context about why we're doing this bylaw and why this bylaw matters. So Perth County's Forestry Conservation Program exists to regulate tree destruction and injury with the goal of improving our forests, soil, fish, wildlife, and water resources. Now the reality is quite concerning. Perth County has only 9% forest coverage. So to kind of put that in perspective with our neighbor in Huron County, they have 16%. So we significantly have fewer woodlots than comparable regions within southwestern Ontario. This makes the protection and proper management of our existing forested areas critically important. So moving on, we're not doing this in a vacuum. The Forestry Act of 1990 defines good forestry practice as the proper implementation of harvest, renewal, and maintenance activities that minimizes harm to ecosystems, wildlife habitat, soil, and water quality, as well as forest productivity and recreational opportunities. Additionally, the Municipal Act of 2001, Section 270, requires municipalities to adopt and maintain policies for protecting and enhancing tree canopy and natural vegetation. So this isn't optional, it's a legislative responsibility. So kind of taking a look of where we're at today and how we got here, just kind of going back in time, this is our bylaw review timeline. So in March of 2024, County Council has directed the Agricultural Working Group to review the existing bylaw. April and May that year, staff researched and reached out to comparator municipalities, particularly Oxford County, with respect to regarding an appeal or an exemption process on behalf of that Agricultural Working Group. Moving forward to July of that year, the working group received the detailed municipal comparison from staff, did an analysis, and then in December, the working group presented the proposed updates based on that comparison and feedback. And then in April of 2025, the working group finalized their recommendations. So kind of where we're at today, again, going back before we move forward, in May, the Agricultural Working Group submitted a report to County Council with proposed updates. June, County Council reviewed everything and directed staff to consult with all the lower tier municipalities. And that's why we're here tonight. This is our last stop of the 4 lower tiers. And then to also host a public open house, which I'll describe and provide details a little bit later on in the presentation. So today, again, we're completing the consultation roadshow before returning to County Council for review of the final approval, hopefully, of a draft bylaw in the new year. So when we look through, we look at what council asked, and council asked the agriculture working group to review the forest conservation bylaws of specific municipalities, those being Oxford, Huron, Wellington, Chatham, Kent. But then the working group went above and beyond that, also included Middlesex, Bruce, and Grey counties to kind of give a real comprehensive best practice kind of overview. The full municipal comparison and literature review was included as an attachment to the June 5th report that went to County Council. And if anybody would like that, I'd be happy to supply that through the clerk, and we can get that information to you. So we're looking at the proposed changes in the bylaw. There's really four main sections. One is the definition clarification, which is adding orchards and Christmas tree farms to the definitions to have, again, something that is clearly defined. Next is the windbreak addition. So again, explicitly describing windbreaks, clarifying whether or not they're included in the regulatory limits that we have. The third listed is the consolidated previous amendments. This is just housekeeping. There was 2 amendments that were already passed by council, and this would just be consolidated into the updated bylaw. And then the last one is the adding of a formal process for exemptions and appeals, which again was modeled after Oxford County's approach. So to walk through this in a little bit more detail, first recommended action was the definition. So we have the definitions there. I'm not going to read them. They are posted there, but if you'd like, we can go through them specifically. But these are basically clarifications on important definitions, because then it helps landowners understand what is and is not regulated under the bylaw. So again, providing clarification as we walk through the bylaw and whatever the draft may look like. The proposed definitions when it comes to woodlots, we're keeping the woodlot definition in. There's just one little caveat of adding the windbreak to the woodlot section here was the suggestion brought forward by the Ag Working Group. So with the addition of proposed definitions, we are looking at adding a definition for committee specific. This would relate and refer specifically to the Land Division Committee or other similarly constituted committee designated by county bylaw. So this is a necessary definition if council did go ahead and approve an exemption or appeal process. So we wanted to make sure that we would have a committee that would already be set up and handle these matters. So we do with Land Division, and it would just be a subset of that. Again, the housekeeping piece of this bylaw is just the previous amendments that were already there. Those amendments are listed there and should be on the next slide, maybe not, but they are listed there, and they're in the draft copy showing where those changes were made. Okay, moving on. Excellent. So when we look at this here, this is the exemption and appeal process. This is a significant addition, I would call it. We are proposing an exemption or appeal process modeled after Oxford County's approach. So just walking through specifically here of how it would work. You'd have an applicant, they must first submit a notice of intent. We have a notice of intent process. It's not a permit process, but it is a notice of intent. It just allows us an ability to know what kind of cutting would occur in the county. And once that's completed, they would receive a decision from Marvin or the forestry inspector. If they disagreed with that or need an exemption, then they can appeal to Land Division Committee to walk through that appeal or that exemption process. The committee would then hear from the applicant as well as community input, and then the officer expertise would be making a decision on that information. So the committee would then grant the exemption, grant it with modifications, or refuse it. So those would be the 3 results that they could take on that. So then this whole process, we believe, provides a fair, transparent process as well as community input while maintaining the protection of our forest resources. This is a visualization of what I basically just walked through, but you can see from step 1 all the way through to the end, the notice of intent submitted, there's a decision that's rendered. The applicant then can go ahead and apply for the exemption and appeal, and we walk through the process with the Land Division before a final decision is rendered by the committee. And again, that decision would be final. All right, so moving on to the future here then, the open house. So we're looking at hosting a public open house on December 10th. From 6 to 8 p.m., and this would be housed at the Perth East Recreation Complex in Milverton. So what we'll do is we'll have staff that are going to be present. They'll be available for questions. There'll be a feedback piece. Anybody who can't attend, We do have information, a survey, a feedback form on our website currently. We encourage individuals to go to our website, which is www.perthcounty.ca/forestry, and fill out the feedback form. Give us your information. It'd be greatly appreciated. So if you can't make that December 10th, we still have an avenue for individuals to provide comment. That will stay open for a week past the open house. Just in case you come to the open house, there's more questions you have or more feedback, you can go ahead and provide that information to us a week after. So next steps, again, kind of going back and forward again. So we're just completing this lower tier road show. This again is our last stop. We've been to the other 3 lower tiers. We're looking at the December 2025 there is the open house. Again, community feedback and survey is available. Love to get everybody's input. And then in early 2026, the intent is that we're going to return back to County Council with the final proposed bylaw version, incorporating all the feedback from all these consultations, lower tier roadshow, as well as the public feedback, whether it's the open house or the feedback forms. With that said, I'm going to transition over here to Daryl to give a brief, if time's allotted, process on the prosecution, if that's okay. Thank you.
Anyone on council object to hearing this information? All right.
All right. Thank you, Mr. Mayor, members of council, and the public and staff. Just very briefly, the authority that I am. Can't hear you. What if I speak in the mic? Does that help? Sure. Okay. So I've been appointed by County Council pursuant to an agreement to provide prosecutorial services. I have to do so in accordance with standards that are issued by the Attorney General's office. That standard is titled Standards for Prosecutions by Municipalities. I perform my duties as a prosecutor independent of County Council. The process really starts with Marvin Smith. He's the inspector. He'll go out and he'll notify my office if he's observed evidence of tree destruction. The Municipal Act and the bylaw authorizes the inspector to enter private property, not a dwelling house, but private property, without a search warrant to investigate. I'll usually receive a report from Marvin, and I must then determine whether there's sufficient evidence and that the circumstances require that charges be laid. If charges are laid, then the court process is engaged, and the defendants, of course, entitled to the presumption of innocence. However, if there is a trial or a resolution and a finding of guilt follows, then the court considers an appropriate penalty. In doing so, the most important consideration is general deterrence to discourage others from committing the offense. Since 2021 in Perth County, there's been about 11 or so prosecutions. Up to this point in time, the fines have been relatively modest, averaging about $5,000 plus a victim surcharge of 25%. This fall, I've conducted 3 trials in a neighboring county, and in one of those trials, the total fines levied against the defendant were $400,000. So times are changing. The landscape is getting much more serious, and going forward in my role as a prosecutor, I will be asking the court to impose more significant fines than I have in the past. So that essentially is where it stands in terms of prosecutions. Right now, there is only one active prosecution in Perth County, and that is going through a pretrial process at this point. Those are my remarks.
Thank you. Mr. Sager, anything further?
Through the mayor, no, we're happy to take any questions.
Great, thank you. Colleagues, I'd entertain a few questions if you have them or comments. Deputy Mayor Callum.
Yes, thank you. Through you, Mayor Kaysenberg, and thank you, Tyler, for your presentation. Just a remark with regards to the open house in Perth East. How are we circulating to the citizens to attend that?
Perfect, yes. So through the mayor, we're using our social media as well as I think these meetings have actually been an avenue for us to promote. So we encourage all council members to go ahead and share the information. But we will have information that goes out on our social media as well as the county's website.
Thank you.
Thank you. Anyone else? Councillor Nordam?
Thank you, and through you, Mayor Kiesenberg, thanks for the presentation. The way I read the bylaw, windbreaks aren't considered woodlots, correct?
For that question, maybe I should be the one that answers that. So windbreaks, if they are half a hectare or larger, would still be protected by the bylaw. In terms of planning a windbreak, I would think that most, if it's going to cover an entire field, could very well approach the size that would be protected by the bylaw. So that's an area that there is some friction, and unfortunately, the hope is that with a bit of flexibility, with this new committee that's going to be on board, that perhaps in the appropriate case, some flexibility can be arrived at in terms of protecting some of the windbreaks, pardon me, um, that would otherwise be protected by the bylaw in terms of wanting to modify windbreaks, trim them back, that sort of thing. And the idea being that right now, the way that the bylaw reads, it's either or, either you're guilty or you're innocent, and there's not a lot of flexibility to it. So what we're hoping is that with this amendment, that perhaps that little bit of extra flexibility that might be appropriate in certain cases will be available to those that apply for it.
Okay, thank you. Anyone else with questions or comments at this point? Can I just ask, with regards to the fines that you mentioned, how is that provisioned? Is there through the Provincial Forestry Act, or
So
are there?
the bylaw actually sets out the what the fines are, which really track the Municipal Act. So the basic rule is that for each offense, the fine can be either a maximum of $10,000 or $1,000 per tree. And so the case I mentioned, the total of 6 acres of trees were taken out. You can imagine how many thousands of trees that was. I mean, we're estimating some estimates were 10,000, some were 20, some were 25. In any event, a large number of trees. And so the prosecution in a case like that would choose the $1,000 per tree, a branch, if I want to put it that way. And then, of course, whatever submissions the prosecution made would, of course, be answered with a defense submission, and also ultimately the court would be the one that decides what the appropriate fine would be. And in that particular case, the facts were pretty egregious.
Thank you. Deputy Mayor Kellum.
Yeah, last comment, and thanks again. So just to sum it up, so the best scenario would be for the citizen of North Perth or for the county to reach out to Marvin Smith to ask him to come to their property to seek and see what trees are allowed to be cut and not to be cut.
Absolutely the right thing to do. Or if you simply file a notice of intent, then I expect that Marvin would go in and take a look and see what it is that's proposed. And if there was an issue, then Marvin would bring it to the landowner's attention, and the process, would be triggered in terms of whether or not the proposed cutting would be permitted by the bylaw, and if not, would it be appropriate to make a submission to that committee?
Thank you.
Great. Anyone else with questions? Councillor Rothwell.
Thank you, Mayor Todd, and thanks very much, Taylor and Daryl, for the presentation. The first question I have is in a situation with respect to the proposed bylaw, if there is in fact an issue where, similar to the circumstance you talked about, where 6 acres of woodlot were cleared, one thing is the financial piece. Is there a requirement for replanting of that 6 acres, or is that property owner allowed to cultivate that land, for example?
The difficulty with a replanting order, unfortunately, is because the maximum limit for a probation order is 2 years. everybody knows that, just planting some trees, you know, small little starter trees, 2 years is not going to cut it. If they're not properly cared for a much longer period of time, that replanting will probably not be successful. And so, as a practical matter, replanting is not a preferred approach. And even though theoretically it should be, the other problem is that it places another burden on the prosecuting authority, in this case, the County of Huron, to inspect, manage, and if there's been a breach, then we're in Superior Court spending more money on legal fees and trying to enforce an order. In theory, court orders should be followed. I can tell you, in my experience, not everyone does as they should, and for the most part, replanting orders are not requested. However, there is jurisdiction to have a court order them, and I have in the past applied for and obtained replanting orders, but they have to be very detailed. They have to specify the species, they have to specify the area, and they have to specify a care plan.
Just further to that point, I think more of a comment than an expected answer. With the price of agricultural land, unfortunately, this may be a cost of doing business for some property owners.
So, responding to that, I agree with that 100%, and that's been the driving force with most of what I see in terms of my role as a prosecutor. And that is why the fines have to go up substantially, because it cannot be a cost of business anymore. I think that the perception has been until recently that I'll cut the trees and I'll pay the fine, and that just cannot continue given the 9% of forest cover we've got left in Perth. There has to be a change, and it's coming.
My last point through you, Mr. Chair, is the impact of the emerald ash borer on woodlots within Perth County, and as to whether or not any of these proposed changes in the bylaw are going to provide clarity in terms of density of trees as a result of dead emerald or dead ash trees that have had to be removed, and as to whether or not what was once a woodlot is no longer a woodlot. Is there any clarity that the proposed bylaw can give in that respect? Thank you.
The bylaw will not change as a result of the emerald ash borer or any other insect attack or other issue with respect to our forest cover. What would happen would be that in that particular situation, the density requirement in the bylaw may not be met. And what was once a woodland or woodlot would no longer be one because it does not meet the density requirement. Um, the um, and as a practical matter, I'm not sure how one would say, well, it used to be a woodland until the insects showed up. As a prosecutor, I'd have a real difficulty proving that one, but I do what they ask me to do, and I go where they send me.
Okay.
Thank you very much, Mr. Mayor. Appreciate it.
Thank you. All right, colleagues, I think we'll move forward. We do have a resolution. I think the county would appreciate us passing one. As follows, the Council of the Municipality of North Perth receives the Forest Conservation Bylaw Review Update Report for information. Moved by Deputy Mayor Kellum, seconded by Councillor Duncan. Any discussion or debate on that one? Seeing none, let's have that vote. Councillor Andreessen records a manual in favor vote. We have 9 votes accounted for, and that is carried. Thank you, Mr. Sager and team. Appreciate your patience with my pronunciation of your surname, Mr. Lawyer. All right, let's move to item 8.2. Next, we will hear from delegations Gerald Kolkman and Henry Koskamp, who wish to speak to the forestry bylaw draft that was just presented, at least at the overview level, in the earlier delegation by Perth County representatives. Gentlemen, at your discretion.
Your Worship, Kessenberg, Deputy Mayor Kellum, and Council. Henry and I appreciate being able to speak to Council this evening. We have a somewhat different approach to what was just presented by the county as a proposal. We would, in the crafting of the bylaw, we would encourage to incentivize tree planting. We're all for tree planting, and instead of heavy emphasis on penalizing, because I noticed in the Planning Act that in 2017, the province has requested municipalities to increase tree cover to mitigate climate change. So there's going to be a push on tree cover, and it could be a win-win situation with the agricultural community if it's done right. You're not going to get uptake very much at all if you, like for instance, windbreaks. If you call them a woodland or a woodlot, you after 0.2 of a hectare, now it becomes a woodlot or woodland. How many farmers are going to plant, the, and with that there is no that they're hamstrung in the future to do anything. And farmers have always used windbreaks as tools for wind, mostly for erosion control. Yields go up with windbreaks, but not around the whole perimeter of a field. You know, like an L-shaped windbreak would be ideal. And even solid windbreak isn't really necessarily good. A little more porous windbreak is better even. I'm going to focus on three areas. One is the size of the wood. I noticed they've included a wood lot, and in the current bylaw, there is a wood lot category. It's been there for a long time. In the 7 counties that were studied, 5 of the counties use 1 hectare as the protected woodland. There is no category of woodlot in their bylaws. In the Forestry Act, there is no category of woodlot. It is a made in Perth County inclusion, so it's not coming down from the province. Okay. Sometimes a small 0.2 hectare woodlot in the middle of a field can be a nuisance. And I'm not saying to tear out all trees, but when more than 50 years ago, when our forefathers left some tree cover, they realized, like in Kansas, where it was clear cutting, there was the dust bowl, so they knew they had to leave some trees there, but it was done somewhat in a haphazard way. We protected what was left by our pioneers, but it is kind of the new way going forward would be the use of windbreaks. Windbreaks do far more good to farmers for carbon capture. Every tree in a windbreak captures more carbon than a tree in a woodlot. It's just the canopy of a woodland that there's photosynthesis taking place. So every per tree, more carbon is captured in a windbreak because there's sun branches that are getting sunlight on all sides. We are so happy that the proposal includes an appeal process. We think that the appeal process should be free of a conflict of interest, that it is truly an avenue where there is a dispute with a decision that a landowner could go. And we are, because of we would like to see the agricultural perspective brought into forestry conservation a lot more than it is. And that's the reason why we're presenting. We have consulted with a lot of farm groups. We've made presentations to farm groups, and so the document we prepared that you probably all received has been circulated in a lot of different farm groups, Federation of Agriculture, Christian Farmers, Grain Farmers of Ontario, Soil and Crop Improvement Association. So it is being circulated. Now, in regards to 270 in the Municipal Act, it says there, a municipality shall adopt and maintain policies with respect to the following matters. Item number 7, the manner in which the municipality will protect and enhance tree canopy and natural vegetation in the municipality. So what does manner mean? It's a way in which a thing is done or happens. So in section 135 of the Municipal Act, it says a local municipality may prohibit or regulate the destruction or injuring of trees through the creation of a bylaw. This is where it mentions bylaw. It never mentioned bylaw in 270. It just says the manner in which municipality can protect tree cover, okay? I'd just like to bring it into perspective. Henry, just grab my arm if you want to chime in. Maybe you can.
Just double checking, you get 4 minutes in, so just.
Okay. Henry and I have been collaborating a lot, so I don't want to steal all this thunder. To put it in perspective, like I've heard over and over again, we need 30 to 50% tree cover in Perth County. Can you imagine Perth County being covered over 30 to 50% tree cover? Perth County has a very rich agricultural land. Like it's a phenomenal asset. It's a big driver to our economy, and a forestry bylaw affects mostly agriculture. I read in the Planning Act that if a subdivision in town goes in, if it's an approved subdivision, they can remove the woodlot. Well, you know, there seems to be two standards, one for agriculture and one for building subdivisions in town. There's two standards. So, okay, you take over.
Thanks for having us this evening. Where I'm going with this is we wanted to let's start over. Our goal is to get trees in the countryside. The best management practices on a farm is windbreaks. It controls soil, water erosion, as well as snow management, strategically placed trees. So why would we limit the size? As soon as we limit the size, as soon as you plant over 0.2 hectares, you've essentially, it now goes into a woodlot. Our proposal is it goes to a hectare. A normal farm is a kilometer long, okay? 6 rows of corn. The length of a farm is already over an acre, okay? It's 5.4 rows of corn. So if I do windbreak, the length of a farm, 30 feet wide, I'm 2.2 acres already. If that goes into the category of a woodlot, and it goes into the oversight of the county, I've lost $30,000 an acre in value. Now, I can justify putting the windbreak in. I have a problem being punished with losing $30,000 of equity. It should be a reward. It should not. And we're not looking for financial reward. We're just looking for the freedom to plant. And who's the best caregiver? The person who plants, waters, prunes, and takes care of this is the best caregiver. Okay? The oversight of the county, I'm not sure, is going to incentivize the tree planting. We went through several of the definitions, and one we really enjoyed working with was a tree registry. And the purpose of the registry is if you planted a bunch of windbreaks on your farm and plantations, and our proposal says no size limit on windbreaks or tree plantations. Okay, but the person who planted them has two options, or maybe more. You can register your tree plantation so that the next owner doesn't rip it out. Okay, which basically would mean it's going into the definition of a woodlot at county level. But if you're going to put in a plantation for the purpose of your retirement, in 20, 30 years you want to harvest it, okay? You also have the option then to register it so it can go back into farmland or pasture, okay? It's just an RSP from a farmer's perspective. Some of the other concerns is, well, we asked that professional courtesy. Before you just trespass, you talk to the owner before trespassing. And I think it'll have to be addressed for biosecurity issues. And we'll have to get further into that one. And my time's just about up. So all I ask is if you can step back, put a put a different set of glasses on and look at it from a different perspective. How are we going to get trees planted? Okay, we can incentivize without money. Just take away the rules and let's get these trees planted. It is best management practices, and it is a goal for climate change. All these agendas, they all line up. We actually have a lot in common. And so, and I ask if you could see if you can support many of the concepts we presented.
Okay, thank you, gentlemen. Colleagues, questions or comments for the delegation? Councillor Nordham?
Thanks, and through you, Mark Hasenberg. Yeah, you guys do bring very valid points, I believe, on the windbreak. I know right now on our farm we're looking into planting some windbreaks and with the Conservation Authority, and I think they give us a 15-year window where we have to take care of the trees and make sure that they're properly taken care of. But yeah, I agree. Once you get over that 0.2 acreage, or is it hectare?
It's a half acre, 0.2 hectares.
Yeah. So right now we're thinking about planting. I think they had around 200 trees in the plan, but I can see his perspective, and now I'm also starting to rethink my plans as well. So I think the county is here. They're hearing comments and comments from us as well. Thanks.
Thank you, Councillor Nordham. Did you wish to briefly respond?
In regards to, if you think about it, like along your laneway, like a lot of pig barns now have to be built to the back of the property. If you put a living snow fence the length of your farm, and let's say you want to make a change on your barn and you have to move these trees, okay? If it's in a woodland, like a long, narrow woodland, you may or may not even get permission to move them. Whereas if it is in a windbreak with no size limitations, there would be no conflict.
Okay. Thank you. Anyone else with questions or comments? Deputy Mayor Callum?
It's just one comment, and thank you for your presentation, Gerald and Henry. So you spoke about and we are encouraging windbreaks. So you spoke about the land that is being taken away on your farm. If we were to compromise in what you are planting for years to come and allow you to take away from other woodlots, would that help?
I think we need a new approach. The new approach, which is a win-win, would be windbreaks. It does more good to farmers. These irregular shaped, you would get more area covered in trees. You would. So these 0.2 little small pieces of wood lot don't do a lot for wind. The wind just blows around each side easily, and it's even more intense on the edges. A windbreak does a lot more for the climate and for the land.
I think the answer is we're going to lose some half acre and 1 acre pieces, but I think we're going to gain a lot of 2 and 3 acre windbreaks. And the other one is let's change this into communication. There may be people out there with marginal land who would love to put it into, who would love to get it planted with the right species in the right locations. And I think we can marry things up here. And there's a lot of protecting the half acre. I think is costing us tens and 20 acres of windbreaks.
Thank you. Okay. Anyone else? Last comment or question? Okay, gentlemen, thank you for coming out tonight. Appreciate that. Does council have any will here before we move on to the next delegation? I think the comments have been heard. All right, next is item 8.3. We will hear from Curtis Martin, who wishes to speak about the Gowanstown Vintage Barn in advance of item 9.1.1 on tonight's agenda. Mr. Martin, at your discretion.
Mayor and council members. Glad for the opportunity to present my proposal. I have a barn that I've been using for invited guests for weddings and stuff. And my understanding was that if you have a dedicated fire watchman and it's invited guests, that's not considered public. But I found out that might not be the truth. So my dilemma is that to bring it up to code for the public, I have to go through a lot of expenses, and to cover those expenses, I'd like to use a barn as we make the changes. If we find out what the minimum requirement would be for next season, we could do that and then use a barn and have income and then upgrade it. I did several upgrades. I didn't know the procedures, so I was told I need a fire hydrant, so I put a fire hydrant in. I was told the lane needs to be widened, so I widened the lane. I got information I thought was from a good source, and I found out I did it the wrong procedure. So I need to find out the procedure that needs to be done. I guess I need to apply for add a zoning change or something first step, and then a bunch of other improvements that need to be done. Like the septic system is one of the big thing. I was wondering if a holding tank would be appropriate for until the proper weeping bed can be put in and stuff like that is what I'm proposing. So I think the next would be questions, if you have any questions.
Okay, thank you, Mr. Martin. Colleagues, any questions or first comments? I will note that under 9.1.1, there is further deliberation and a staff report on this, so there will be opportunity. But if you have questions for Mr. Martin, by all means, let's have them on the floor. Anyone? Okay, Councillor Andreessen.
Thank you through you, Mayor Kasenberg. Mr. Martin, I'm just wondering, you said you had some questions about, what the expectations were. Have you been working with the department around permits and, getting advice about next steps so far?
Yes, we had got engineers in for the weaving bed for the building. Now there's controversy of the code. The engineer doesn't have the final say, so I'm wondering why we bother with engineers if they don't have the final say. But yeah, I got engineers in for the weeping bed and for the building improvements, different. And I had asked at the fire station what requirements is for the fire hydrant, and thought I got good advice and put it into those specs. I had asked to get it inspected a couple of times, but they decided it's not appropriate to inspect it.
Okay, anyone else with questions or comments? All right, thank you, Mr. Martin, for presenting yourself tonight to council. We appreciate it. There'll be more a little bit later. Okay, colleagues, there are two additional delegations. Several of us have declared conflicts of interest, so several of us will be escaping at this point. And Councillor Duncan, the chair is going to come to you.
Please note for the minutes, all of the members that have declared a conflict have left council chambers. And I'll invite the delegation with regard to transfer of Perth Meadows to United Housing from Heather Bentley and Carol Barber.
Oh, no, that's good. Oh, I see this. Yep. Okay. Good evening, council members. I was addressing Mayor Kasenberg, but I guess he has a pecuniary interest. So I will address the remainder of you. I am here representing the investors whom are the residents of Perth Meadows. Last week, we were advised that the municipality of North Perth was transitioning the property known as Perth Meadows to United Housing. Following our meeting, there was a flyer that was distributed to everyone, and this is the flyer I'm referring to. And it specifically notes that the residents' needs come first. The transition plan includes listening to the residents and ensuring concerns are addressed. We, the residents, are very concerned about our homes and our investments that we have made. Last Wednesday, November the 12th, at approximately noon, we received a notice indicating that there was a meeting to be held on Thursday, November the 13th at 10 a.m. Concerning upcoming changes that would be happening at Perth Meadows. No agenda, no indication of the purpose of the meeting was noted. On Thursday, November the 13th, the CAO, Chris Snell from the municipality of North Perth, announced that Perth Meadows was transitioning from the municipality of North Perth to United Housing. This was the first communication from the municipality to the investors of Perth Meadows that this was even happening. We are here to express our concerns over the handling of the process of such a magnitude without consultation of the residents who hold the biggest interest in Perth Meadows. We, the residents, hold the investment in the property financially. A letter was sent to each member of council on Sunday morning outlining our areas of concern. This letter was signed by approximately 50% of the life lease holders. We know that there are other life lease holders who wanted to sign the letter that we sent, but we were unable to reach everyone because of the time constraints placed on us to get this submitted and set in motion. As not to repeat exactly what was noted in the letter sent to each of you, the information included in that letter is intended to be part of this presentation, and I will focus on the items that we are most concerned about. The first item being the lack of transparency. We were given less than 24 hours notice about upcoming changes at Perth Meadows with no agenda details, which is a violation of the principle of contract law and principles of procedural fairness, which includes adequate notice and providing for decision making. The municipality has had no conversation with the residents at Perth Meadows prior to last Thursday, and according to Ashton's report to council for tonight's meeting, these discussions with United Housing commenced in April of 2024, which has given you ample opportunity to have open dialogue between the municipality and the investors of our community. We should have been given more than 2 business days to seek legal advice, to ask municipal staff questions, and be given the opportunity to provide input on the sale of our property. This too is a violation of procedural fairness. The question that keeps coming up to us is, why is this happening and why is the town selling our property? The next concern is the financial uncertainty. We have received nothing in writing to ensure that our investment in Perth Meadows is being protected and that the terms of our life lease agreements will continue to be upheld. We are the investors of Perth Meadows, and we have bared the burden of the finances to ensure that our property remained a sustainable property at no cost to the taxpayers of North Perth. And the property is being listed on your bylaw as being sold for $1. Has this information been in the public forum at a council meeting prior to tonight's meeting? We were led to believe at the meeting last Thursday that the deal was already done. Nothing was mentioned that a bylaw was being passed and information being brought to council this evening. We had to uncover this information on our own. No financial information about United Housing has been provided to confirm their viability to undertake such a venture. At the meeting last week, they stated that the intention for purchasing our property was to leverage it for other developments. What exactly does that mean to us, and does it put our investment at risk? Also in Ashton's council report for this evening, it states that through this transfer, United Housing will repay the $800,000 promissory note it has with the municipality. This note was issued to the United Housing Downtown project, which confirms that our project is being leveraged for other properties, as we are not affiliated with the downtown project in any way. Our next concern is the enjoyment of property rights. At last week's meeting, we were advised verbally that nothing would change, that everything would remain the same. But again, we have nothing in writing to confirm that this is the case. In today's society, if it's not in writing, then there's no proof of any agreement. Verbal agreements no longer exist. Our rental residents are also very concerned about the future of their home at Perth Meadows and what their future looks like going forward. We have not been provided the opportunity to negotiate in any such manner. We want assurances that the property will remain a 55-plus community and what the future looks like going forward. We want protection for our investment. We do not want to become a property that does not share the purpose and intent of Perth Meadows that we have invested in. We want assurances that the branding and promoting of our property remains as a highly sought out 55-plus life lease community, with the key target market being those who are 55-plus and looking to downsize and purchase in an investment property. This marketing plan should never change without the approval of key investors, being the leaseholders, as change outside of this branding has negative impacts on the value of our investments in Perth Meadows and puts our investments at risk. The next area of concern is the impact on community identity. A lot of the residents are concerned that there will be a stigma placed on our residents should our property become part of United Housing under the umbrella of United Way, because both names automatically translate to charity case in the minds of people who read such signing, and we feel that this is bad branding. At this time, we are requesting that the passing of bylaw number 123-2025 be deferred, that conversations commence with the residents of Perth Meadows on the sale of the property, and that consideration for other options if a sale is to go forward. A written memorandum of understanding be drafted with the terms outlining should a sale go forward. We would like to see the following information included in that memorandum of understanding. Confirmation that life leases will remain intact in the same enjoyment of value continue as signed originally with the municipality of North Perth. What our day-to-day life at Perth Meadows will continue to look like. Planning for the future, outlining any changes that the potential purchaser could have or is planning. Continue to be an investment property, meaning that any new residents would be purchasing their units. The balance of life lease units to rental units remain intact as status quo, no additional rental units being added. And then what happens after 2029 when the low rental obligation contract has been met, what the future looks like for the current rental tenants, and any additional information that could come forward during any future discussions. We have built and continue to build a community based on shared values of food, having monthly lunches, potlucks, and barbecues in the summer, enjoying fun in our common room with daily organized games. And we're a family. We enjoy helping one another when anyone is in need. And we have built friendships where every night there is nightly chats in the common room. And many residents came together during the Blue Jay playoffs and watched it together in our common room as well. I know that I can say we all love it here at Perth Meadows, and we just want to ensure that our investment is being taken care of. With that being said, we hope that we can count on council support tonight to defer the passing of bylaw number 123-2025, and that we can start a process of a more open and transparent conversation between both the municipality and the leaseholders of Perth Meadows to ensure that we have the opportunity to seek legal advice and be comfortable with any decisions being made about our investments in Perth Meadows. Thank you.
Thank you very much for your presentation. Council, any questions? Okay, seeing none, thank you.
I was just here to handle any questions with.
Okay.
I don't have any.
Thank you. Next up, we have a delegation on the transfer of Perth Meadows to United Housing. Bert Johnson. Bert, welcome.
Thank you. I don't think I'll use the microphone.
Bert, come forward and use the microphone because that transmits it to the feed to YouTube.
And I don't care about the BTU either. I'm Bert Johnson, and I've been on the board of the board and committee of Perth Meadows for, I'm guessing, 15 or 20 years. We had a board meeting, a committee meeting. Councillor Blazak is your appointed appointment on this board. We had a meeting at 9 o'clock on Wednesday, November the 5th. There was no word given at our committee meeting of any change in the status of Perth Meadows. My next door neighbor can't be here. The mayor can't be here, some of the other ones, but I'm wondering who made the contact that housing wanted to buy, take over, run, or look after Perth Meadows. How did it come before council?
So I think, Bert, I'll let you continue with your whole presentation, and then we'll go back and we'll answer all the questions at the end, if that suits you.
You're going to keep track of these questions because I don't have them all written down.
Okay.
But in any case, my point in coming tonight and making this presentation is with the board of the Perth Meadows complex should not be involved in it at all. And I agree that council have the ultimate right to sell, give away, whatever, like they did the library and things like that. But I have not heard anything really about United Housing. I did hear that they are having a contentious operation on Twomley. I did read in the paper that they bought the building, what I know as the Deanna Suites building. Haven't seen or heard anything going on it. All I'm wondering about is about the rush for council to get this sold. If there was a problem with it, the board, I thought, would have been apprised of it. I wasn't aware that the town wanted to make some changes, but United Housing certainly want to make changes. Otherwise, they wouldn't want to control it. There's something to be made in it. I don't know whether it's money or whatever, but there's some reason that they want to operate it, and I don't see it as being a benefit to the residents that live there. Housing want more houses and families and so on. I think I can speak on behalf of seniors. We don't want kids running up and down the hall of our houses. We don't have to rush in the car and go to hockey practices and dancing lessons and things like that. We want some peace and quiet. I don't see that being the future of Perth Meadows. I think that pretty well wraps up what I wanted to say. And you have the question?
Yeah, I think your question was, how do United Housing and North Perth get together to come up with this arrangement? I think was your question.
Yeah.
I'm just gonna defer that to the CAO to provide maybe a little bit of context in where we're at right now.
So as council is aware, we acquired the Perth Meadows property in 2011. At that time, it was really just to protect the community assets, but it was believed at that time that it would be not necessarily a long-standing service provided by the municipality. In 2014, the municipality issued a formal RFP to sell the property. And basically since then, we've taken inquiries or reached out to potential partners over that time to look at operation of the Perth Meadows property. In April of 2024, the United Way presented a proposal to council to look at the operation of Perth Meadows. So since our acquisition of property, we have had several conversations and potential leads on no longer having the property in our ownership, but this is, I would say, this is the first time that council has felt comfortable through the due diligence process of looking at a community partner that embodies the original goals of the original not-for-profit organization that started Perth Meadows.
Thank you, CAO Snell. Does that answer your question?
Yes, other than I didn't get the detail on when the town decided to sell it.
I guess officially, council directed staff to issue an RFP in 2014 to sell the property.
And would that have been at an open council meeting? Because I don't ever remember any of that being public.
The RFP was certainly an official public document that was available on our website.
Okay. Anyway, I'm here to, my point was that I got probably prior to 2011, I was on the board when it went through the problems of not having enough people to pay their expenses sort of thing. And that was cleared up. I assume it's been amortized and so on. So I didn't know that, that we wanted to sell it. I was in the real estate, I might have been interested myself. Anyway, I urge council to defer the decision on selling it that's on your agenda tonight so that the residents and the public can have a little bit of um, insight into the goings on of it. Any questions for me?
Any questions for Bert and council? I don't see any Bert, so thank you very much for your delegation.
Thank you.
That being said, all our delegations are done, so we can call the rest of the council members back to the chambers, and I'll turn the chair back over to the mayor.
All right, I had to log back in. That was enough of a spell there. So let's turn to item 9 on our agenda. First up, our items from the Environmental Services Department, item 9.1. In item 9.1.1, staff brings forward a report in response to council's direction related to an appeal from a property owner pertaining to the building code. That's not environmental services, is it? I think I've got my notes wrong here. Development and protective services. Let's get it right. Building code requirements for a so-called wedding barn located in Gowanstown. The owner, as we heard earlier, has sought some relief through the process, and Chief Building Official Sally McMullen is here to provide more information about the specific location and the framework for decision-making. Ms. McMullen, welcome.
Thank you, Mayor Kersenberg, and good evening, Council. I just wanted to point to the report really, and it outlines the different safety concerns for this building that are of a structural, building fire safety, fire exiting, and appropriate sewage treatment nature. Individually and collectively, these issues are significant. The community members and renters of such assembly spaces have an expectation for minimum requirements for safety, and that's certainly where the building department finds its duty in upholding those standards. Assembly uses around the community are things like churches, community centers, legions, the Ag Hall, for instance. And the unfolding of events in this particular case have led to an order prohibiting use. I did have a productive meeting last Thursday with the agents on behalf of Mr. Martin, so contractor and family member, the wedding planner, and the engineer on this project. And we had a good conversation about due process around the zoning amendment that would be required for this to be a permitted use, and around the complexity of this building permit application to convert this agricultural building to an assembly use. I did offer that I'd be willing to entertain a proposal for graduated improvement, but it would be very unique, and I don't think that should be relied upon as a steadfast solution until we see what that might look like. So in conclusion, I do stand by my order in my duty to enforce the building code, and I conduct that duty independent of this council.
Thank you, Ms. McMullen. I would say that very few questions are in order, actually, but anyone have questions that they'd like to ask at this point for clarification? Okay, I'm not seeing any. Thank you, Ms. McMullen. Is there any will of council on this matter further? Okay, then we move to the next item on our agenda. Let's turn to item 9.2, reports and requested actions from the Corporate Services Department. In item 9.2.1, council is provided with reports supported by work from consultants Watson and Associates on stormwater rates that are recommended. It's not Watson, is it? It's Watson? No, it is Watson. Oh gosh. rates that are recommended for future viability of operations. And we see Mr. Romani, our treasurer. I believe we have Ms. Marks with us tonight as well, our asset management lead, to walk us through what looks like another interesting decision. Mr. Romani.
Thank you, Mayor Kaseberg, and good evening, members of council. So, before you have tonight the stormwater rate study, we do have in attendance Ms. Neal from Watson Associates to walk through the technical details of the stormwater rate study. And I want to take a moment to go through staff's recommendation before we bring her forward. So to recap, the 2025 operating budget included a stormwater levy for listable properties of around $300,000. The rate study now identifies that we'll need roughly $1 million in 2026 when contemplating the operating and capital costs, increasing to around $3 million by 2035. In developing the 2026 budget, we also know that our stormwater rate reserve is projected to cause a deficit of more than $6 million by 2035 if we continue with the current funding model. Implementing the recommendations from the study is what brings the gap back under control if we continue to treat stormwater as a user pay entity. After reviewing Watson's modeling, staff are recommending that we continue to use the special area tax rate for now because it is transparent and straightforward for residents to understand. It functions much like an existing property tax system. It is also practical to implement. Listable already uses this approach, and it does not require additional staff or specialized software at this point in time. And importantly, it does not require, as council knows, it will be replacing, we will replace our ERP within the next 5 years. At that point in time, it will give us the opportunity to have a system that will be better suited for more complex stormwater billing options as Watson examined. The other options of the study do have long-term merit, but right now the financial gaps for ratepayers and the administrative requirements are simply too large for implementation. To be clear, staff are not disregarding Watson's broader recommendations outlined in the report. We see this as a first step in a long-term transition, particularly as we seem to extend stormwater rate collection outside of the listable boundary. A number of questions have come up regarding the inclusion of the hamlets, especially since they do not have direct capital projects identified in the short term. However, including these areas remains necessary. The hamlets will still benefit from stormwater management through overland flow control, drainage outlets, and long-term planning that protects their communities. It is also fundamentally an equity issue. Excluding the hamlets would shift the full burden of stormwater funding onto the listable ratepayers alone. And from a long-term risk perspective, heavier rainfall, climate change, and infrastructure pressures do not recognize community boundaries. Building sustainable funding base now helps avoid those inequities. The 2026 10-year capital forecast did not include hamlet-specific projects simply because no dedicated revenue for those hamlets exist. If council does adopt this direction, staff will begin identifying stormwater needs through methods such as studies within these areas so that they are fully captured within the next rate study. I also want to speak directly to the rate impact. The increase can be understood and be viewed as significant. Under option 1, the median assessed property in listable would see their current stormwater rate rise from $62 to $176 year over year. While this increase reflects the actual operational and capital requirements of the system, we also recognize that implementing that full amount in a single year is not feasible for residents or businesses. If council supports this direction, staff will return with a multi-year phase-in plan policy allowing households and businesses time to adjust. This will include a separate, more gradual phase-in for the hamlets, who would not be expected to match listable's tax rate for the first year. And finally, I want to emphasize that this direct decision is not permanent. As we gather more information and refine our asset management planning and track actual costs delivering the stormwater program, we will revisit this funding model and to see what best fits at that point in time. So at this point, I'd like to turn over to consultants from Watson for their presentation.
Thanks, Ashton. Good evening, Mayor Kassenberg and members of council, staff, and the public. My name is Nancy Neal. I'm a manager with Watson, and I have been working with Leanne and Ashton quite closely for a few months, as well as some of the other staff here. I just want to give you a brief overview of the findings of the study that Ashton was introducing. We did, as Ashton noted, look at not just the Listowel area, but the Atwood and 3 of the hamlets, which include Gallenstown, Moncton, and Trowbridge, where there are stormwater infrastructure in place. The ditching along some of the rural areas is also considered stormwater, but that area has not been included in this study at this point. We did on July 21st present the preliminary findings to yourself, and then on September 15th, we held a public information session to seek input from the public. They could come in, ask any questions. We had some boards up, a presentation, so that they could try and understand a little bit more in the details. There's also a video online that explains stormwater and the importance of it on your website. Right now, there is throughout these areas quite a bit of infrastructure already in place. So currently, there is just under $60 million worth of stormwater infrastructure in place. Sorry. They include 12 stormwater management ponds, as well as 72 kilometers of storm sewers, and then there's manholes and catch basins. If you were to put enough money away every year in a reserve, invest that so that when all of the infrastructure comes due for replacement or major maintenance, that would cost about $800,000 a year with a sinking fund calculation. So that is a significant amount of infrastructure that needs to be taken care of. As Ashton was noting, we have looked out over a 10-year forecast period with the 2026 forecast increasing quite significantly from where you have been in 2025 and prior years. And then what we have done, and you're looking at a forecast in inflated dollars, which also includes growth in these areas and additional businesses and homes being built and their contributions that would come with a rate that they'd be paying as well once they're in place. The day-to-day operating expenses are anticipated to grow from where they were at just over $388,000 in 2025 to $745,000 by 2035. And then the capital related, which is really paying any debt for capital related expenditures that may be needed or putting money into reserve that you can then pull out of reserves when the need is there, really is the balance and the most significant portion. We are looking at going from 545,000 on that up to almost 2.6 million by the end of the 10-year forecast period. So again, upwards of over 3.3 million in total costs in 10 years that you'll be faced with. We did look at 3 different rate structure options, and that was really developed based on the information that is available right now. One is that special levy that is currently in Listowel and expanding that out to the other areas as well. Another was flat rate based on average runoff coefficients, which is really a number that looks at for different types of properties and sizes of property, the average amount of stormwater that runs off of hard surfaces and into your stormwater system. And then we also looked at a varied flat rate for residential and non-residential based on different sizes, small, medium, and large for residential, small and large for non-residential, that really looked at kind of varying just based on land area. So what that resulted in for the different options was a range with depending on the size of your property and your current assessment. We've given some examples here. Under that special levy, a small property that's under 0.2 acres would be paying about $58 as part of their tax bill right now for stormwater. As Ashton mentioned, that would be increasing for 2026, and then going out to 2035 would increase up to about $388 a property. Now, as you get to having larger properties, that rate would increase accordingly based on the assessed value that you have. What it's looking at is about a $110 increase from 2025 to 2026 for small properties, up to almost $200 worth of an increase for large properties that are assessed at about $455,000. For non-residential, similarly, looking at increases for 2026 in the range of $113 for properties that are under an acre. And then for the larger properties, there is a larger increase anticipated there. As you go down to the other options, there is a change. When looking at the runoff coefficients, the more hard surfaces you have on larger buildings where there's parking lots, think of a mall, for example, or a business where it's mostly asphalt parking around the building, they have faster runoff. And more going into the system, nothing seeping into the ground, their rates would be higher. And then what would happen in that situation is your residential customers would actually see a decrease in what they would be paying. And then the tiered flat rate is sort of in between the levy and the runoff coefficient. Now, as Ashton was mentioning, to go to these other two types of systems, you would need to have systems in place to track the various properties, categorize them, and do updates to them as changes happen. And that's why, for a first step, staff are recommending to just expand that special tax levy over the next few years into the other areas that aren't being charged anything right now on that special levy. Some of the key factors to keep in mind going forward when you do come back to have a system in place that could handle it is whenever you're selecting a rate structure, you want to make sure there's a few things considered. One is the ease of the calculation for not just staff based on the data available, but also the reliance on the assumptions and how quickly that changes. It can become, on some rate structures, very administratively intensive, and so there's a cost of administration to some of the structures that are more than others. The most expensive structures we didn't even look at that are out there in place. There's also a linkage between the amount paid and the benefit that's being received by the homeowners or property owners that needs to be considered, and a fairness as you go to different types of rate structures. You may get more or less equity on actual stormwater running off your property and into the system or not. And then what is the user's control over changing that depending on the rate structure? So if you think of, maybe not putting asphalt driveway in, but keeping a gravel driveway where rainwater can seep into the ground, that would reduce stormwater off your property. That's something that someone could control on their property. Other things are, you can't control. With the special tax levy, the assessment value of your house is set. It's not something you can control, but it's an easy way of implementing a charge to get something underway. If you look at other municipalities that have dedicated stormwater rates throughout the province, there's more and more municipalities looking to put that in place. And you are currently right in the middle of option one of where everyone is on that chart in green, with option two being a lower charge for a residential home, and option three being the highest for you, but certainly not the highest in your comparisons. That is my presentation, and I'd be happy to take any questions that you have.
All right, thank you. Colleagues, questions and first comments. Councillor Andreessen.
Yes, thank you through you, Mayor Kiesenberg. Just wondered if you could provide some clarification around the hamlets. Molesworth wasn't included in the hamlets, but if you could just explain that, I think it might be helpful for the public as well. Thank you.
Yeah, through the mayor, it wasn't an area with a significant amount of stormwater infrastructure in place to be considered at this time.
let me follow up with the obvious question then. So if the hamlets are not currently well encumbered with structures, then why would we ask them to pay? I just want to make sure I understand.
Yeah, there is infrastructure in place in the hamlets. And we have looked out, not just over the next 10 years, but we've looked at the replacement of the infrastructure in place over the full lifespan. So going out 80, 90 years. And although there isn't needs in the short term for the hamlets for replacement of the infrastructure in place, there is needs outside this 10-year forecast, and there may be needs within the 10-year forecast that, as Ashton was mentioning, may be discovered through further study that is anticipated to take place over the next few years. Where right now they would be contributing into the current system, but not maybe drawing the money out to pay for replacement of their infrastructure in the short term. Certainly in the longer term, the money will be there that they're contributing towards to pay for their infrastructure when the replacement is required. So we haven't just put a blinder onto the short term, we've looked at the long term, and to smooth out all of the infrastructure being dealt with when it's needed, starting sooner than later for those that have the infrastructure and benefit from it, paying a little bit every year into the systems is something that, when you're looking at full cost recovery and equity, starts to help. Alternatively, in the years that the infrastructure comes due in those systems now or in those areas, there would be a significant amount of money that would needed to be recovered at that time, and there'd be huge spikes versus starting to smooth out and implement something over a longer period of time. Does that help?
Okay, Councillor Nodum.
Thank you, Mayor Kasenberg, and through you. Generally, hamlet properties, they're on the larger side, like more country property. Kind of what I'm getting out of this is that they're probably going to be getting fairly hammered because they have a large property. Wouldn't that, would you kind of say that, or not really?
Through the mayor, it really, based on what's being recommended by staff with expanding that special tax levy, it really comes down to the assessed value. So if you have a larger piece of property with a larger home or business on it that has a higher assessed value, then yes, they would be paying significantly more than someone with a smaller property or a lower assessment. And that is the difficulty with the tax levy system. It isn't necessarily directly related to the amount of stormwater running off your property. But it is a surrogate for, just like you collect for any other service under the property taxes right now, to get funding to a much needed system that needs to be maintained.
Okay, Councillor Duncan.
So my comment and question here is maybe going to get a little complicated, so everybody bear with me. And it refers back to Ashton's comment about equity. With area rating, as opposed to leaving this in the tax levy, we're asking one group of individuals to pay for municipal infrastructure and another group of individuals not to pay for municipal infrastructure. Yet, the one group ends up paying for all municipal infrastructure in the municipality. And where I'm going with this is, anytime there's a municipal drain crossing on a rural road, the municipality is assessed for that crossing. Sometimes those assessments that the general levy carries are larger than the assessed landowner's project. So I guess where I'm going with this is, if we area rate the stormwater, where you have urban residents paying for their stormwater, but then they also pay on the general levy when there's rural stormwater projects, I guess I'm looking at equity and fairness there.
Through the mayor, and Ash, you may want, do you want to jump in on
Yeah,
that one?
I think we'll let Mr. Romani take this one.
Through Mayor Kasenberg, particularly with the municipal drain side, the stormwater user pay system does have a contribution from the tax levy baked into it. So I think it's around, I want to say $300,000 to $400,000 is a constant tax levy. So the entire municipality contributes into the stormwater program for those specific drainage assessments. On top of that, we have the dedicated user rate. Right now, the listable boundary that is paying for specific stormwater works in general as well. So I'm hoping I'm answering your question through that, but essentially overall, we're glad to see us now.
Okay, let's see us now.
I'm just going to say I can add to that too. Those drainage assessments that Councillor Duncan is referring to is water contributed by the roadway. So that is sort of why it's assumed to be picked up by all the taxpayers. It's water contributed by the roadway under the Drainage Act. Sometimes I think that levy is too high, but that's the way the Drainage Act has been interpreted for a long time, and that's water contributed by the roadway. With this, we're looking at private water coming off private properties.
Okay, Councillor Duncan.
So are we making allowances then for the water contributed by the urban roadways? They all contribute water to the stormwater system too. Like it's the same.
Okay, who's answering this one?
Do you want to? Go ahead.
Ash can correct me if I'm wrong, but through the mayor, right now there are stormwater management through the road systems throughout the municipality that is partially recovered through property taxes. Then there are other stormwater works that are specifically being recovered in the Listowel area, where infrastructure in the other areas of the hamlets and Atwood, similar type of infrastructure for Listowel, but that is not being recovered through an additional special levy. Part of the phase in of the rates or the phase out of the drainage charges right now in those hamlet areas is part of what Ashton will be bringing forward at a later date. But it is anticipated that there will only be the special levy charge in these areas, not the drainage charge on top of that. So it's one or the other. However, the general tax levy, again, you're not at full cost recovery as to what you're looking at here, because you're right, we have not included any of the rural properties in the calculations. So there will always be a portion of the stormwater works that will need to be funded from property taxes. So is it perfectly equitable? No, it's not. To get to pure equity, everyone would pay their proportionate share, regardless if they were in an urban area or a rural area. There's, to put that type of structure in place, the most equitable structure is also based on pure imperviousness measurements for every property. But the cost of implementing that and administering it is so incredibly high that you have to balance somewhere between pure equity and something closer to what will help to recover the costs that you're going to be faced with in the future. It's not a perfect science. Right now, it's step one in the process, but you're absolutely right, Councillor Duncan. It's not pure equity at the moment.
Okay, staff looks satisfied. Okay, Councillor Duncan, one more.
So in that case, why do we bother to area rate at all? Why don't we just leave it all on the tax levy and consider it asset management and deal with it that way through the whole municipality and treat everybody the same?
Okay, Mr. Romani.
Through Mayor Kasenberg, that's certainly an option. We can roll it all into the tax levy. Just when we look at our infrastructure levy through our asset management plan, referenced in the report, I believe they said 4%. 4% of the levy of 423,000 is attributable to stormwater. Now, going through the study, we've uncovered a lot more data, understood our replacement costs a lot more, so that would influence the amount we do recover. So that is an option for council here if they choose not to go forward with the special area rate and make it a user pay system. Yeah, I'll leave it at that.
Okay. All right. Councillor Nordum.
Thanks, Mayor Kasenberg. So on the report, Appendix B, I believe it was page 210, 213 of our agenda. So anyway, it's the detailed rate calculations, and it gives that 10-year forecast. Is it looks to me like you only listable Atwood projects. Is there any ones from the hamlets there? Like I see a street sweeper and then maybe another street sweeper. Is that the only one that's there? Or thank you very much.
Through Mayor Kasenberg, there's no specific other projects for the hamlets, but one thing we will be including if the rate study goes forward is to do some studies within those hamlet areas so that we can identify those projects so we can begin actioning and including in the planning process, particularly when we do the next rate study as well.
Yeah, through you, Mayor Kasenberg, I know there's some areas in Gallenstown that are fairly wet, and I think they would be a little miffed if they were paying a stormwater rate while their basement's flooding. So just, we really need to make sure that we study these areas, and because, I mean, if we're just focusing on Listowel and Atwood for 10 years, I am not supporting this. Fair. Thank you.
Okay. Anyone else with questions or comments? Colleagues, do you want to entertain the resolution, or do you have some other preference with regards to how to proceed at this point? Councillor Johnston.
So a question. So Ashton, if we're looking at the phased-in implementation strategy, that would definitely leave some of the hamlets till further down the line that we would be assessing them, the special area rate. If we were to look at your recommendation that supports option one, the special property tax in the 5 towns and hamlets, but then we go with the phased implementation, would those hamlets be part of that phased implementation, that they'd be further out there before we start collecting from some of them?
So, thank you. Through Mayor Kasenberg. So the intent would be essentially we would have 2 special area rates. We would have the special area rate for Listowel. So right now we collect $300,000. It's roughly 60 some odd dollars for the median household. And then we would establish a new special area rate for all the other hamlets. Now, when we quantify the value we want to levy against all those properties, we will consider what the impact is going to be on the median assessed household. So depending, we'll take it back and determine what's the impact should it be $20, or if council wants to opt to have nothing, it's within your power. But we would go back, understand what would be an appropriate amount to levy within those boundary areas outside of Listowel.
Okay. Any other questions? All right. Well, none of you have suggested another strategy, so why don't we put the resolution into the record and see what happens? As follows, that the Council of the Municipality of North Perth endorses the stormwater rate study prepared by Watson and Associates Economists Limited, and the Council supports option 1, the special property tax in Listowel, Atwood, Moncton, Gowanstown, and Trowbridge as the preferred method for stormwater funding in North Perth, and that staff return with a phased implementation strategy for the special property tax funding model. Can I call for a mover? Councillor Johnston, and seconded by Councillor Rothwell. Any further discussion or debate or comments? Councillor Johnston.
I was a little nervous about this recommendation until Ashton just answered that last question I had about how the phased implementation can work. So I'm very much in favor of this now.
Okay, thank you. Councillor Duncan?
I'm going to be voting against this. I think it should be left in the general tax levy as an asset management plan. So unfortunately, I can't vote in favor for this.
Okay. Can I ask the question, if it was left in the general levy, like if it was moved to the general levy fully, and we still had the obligation to make the system essentially whole, What would be the impact on property taxes, generally speaking? Can we assess that quickly, Mr. Romani?
We would certainly have to go back and do more detailed analysis on that, but I know for a fact right out the gate, we do collect $300,000 from the listable boundary. So that automatically would transfer right over into the general tax base, plus the additional amount that's been analyzed in this stormwater rate study. So we can certainly look at the operational costs from the operating and capital costs and roll that in accordingly. But it would definitely be at a minimum $300,000, so or a 1.5% increase at a minimum.
Okay, thank you. Any comment from CAO? You're looking like you might have something to say.
I was just going to mention we could include that as part of our information that we bring back as part of the phasing option, just as information so council would have an idea.
Okay.
It's pretty tough to, I think, put staff to give us a real firm number tonight, but we can bring that as part of the information back.
Okay. The resolution does suggest a direction, though, right? It doesn't suggest going the direction that Councillor Duncan has suggested. It suggests choosing option one. So if we adopt the resolution, then Council is committing to putting us down this path of this special property tax that is extended to all the areas, just so that we understand procedurally where we are, unless there's disagreement from staff. Is there disagreement from staff that that's where we'd be? Okay. Colleagues, anyone else wishing to comment? Councillor Estes, you look like you're about to lean forward.
Yeah, thanks, Mark Haseberg, through you. I'm just confused, sorry. This phased-in approach, what's the years? I'm not clear on that.
Yeah, through your case number. So that's what we would come back and bring for your consideration. So I think we were looking at least a 10-year, minimum 10-year timeline of where we would consolidate all the rates. But again, we want to be mindful of what the actual impact is going to be on the property owner.
Thank you.
Okay. Anyone else? We have a resolution that's been duly moved and seconded. I think it's time to consider a vote. Let's have it. And so that is defeated. Colleagues, I think our question now then remains what the next step might be. We should probably give some direction to staff about how to proceed at this point. Councillor Duncan, did you want to navigate us through that?
Yeah, I think I'd be quite happy if you brought back what we discussed, and then we can make our decision once we have all the information in front of us.
Okay, so that includes a implementation towards the full levy of the municipality general tax base. Is that, yep, that's what you intend?
Yeah,
right.
for sure.
So the resolution should read something like the council directs staff to bring back a report considering the options that includes an extension of the funds needed to the general taxation levy. I think that's the word we want. I hope that's the words we want. Does that sound right to everyone? All right, Councillor Duncan, are you going to move that? Thank you. Seconded by Deputy Mayor Callum. Thank you. Any further discussion or debate on this one? Councillor Nordum.
Thanks, Mayor Caseberg. I won't be in support of this motion. This council, development charges, we always say development should pay for development. I'm going to say stormwater should pay for stormwater. Thank you.
Okay, thank you. Anyone else? All right, we have a resolution. I'm trusting the clerk table to have something that is presentable to us at this point. If you're ready, let's have that vote. Oh, yeah, eScribe just decided to shut itself down for me. That sounds like Deputy Mayor Kellum as well. Okay, perhaps we should do a manual vote then. All those who are in favor of this resolution and opposed. Okay, that is carried. Thank you. So staff is so directed to bring this back. Let me get back into eScribe. Everyone else getting in? Yeah. I think, in fact, I'm not getting back in. It's locked me out, it would appear. We're going to call a recess at this point, a health break. Let's take 10 minutes, come back at 10 after 9. Thank you.
Entertaining council meetings before.
Can we get Sarah, whoever is on, figure out? I'm worried that I startled people with hit the desk a few times, but time to get back to work. All right. Up next are reports and the requested actions from our operations department is item 9.3. As item 9.3.1, council is presented with a report pertaining to the tidying up of some ownership matters through lands exchange on lands where parts of the North Park Trail are encroaching on private land. Development Coordinator Celine Mayhew is with us to take us through the proposed swap of lands. Ms. Mayhew, nice to see you again.
Good evening, Mayor Kasenberg and members of council. I have some diagrams up on the screen here just to make things a little bit clearer. The purpose of this report is to request that council declare municipal land surplus to facilitate a mutually beneficial land exchange with Dunnigan's Haulage. So in this diagram, the yellow is land that's currently owned by Dunnigan's Haulage, and that property is not going to be changing. That's part 2. The red property is also currently owned by Dunnigan's Haulage, and then the blue is municipally owned lands. So the municipality received a request from the owner of Part 2 on the reference plan, which is that guy there. He wants to adjust the property boundaries in order to create a more regular and functional lot configuration that would better support future development. During the review, it was identified that a section of North Perth Trail, which is right adjacent to the red, long, skinny guy, is currently encroaching against the property. So to address both development needs and the trail alignment, staff have worked with the landowner to develop a proposed land exchange. This exchange would optimize the developable area for Dunnigans while ensuring that the trail remains fully contained within municipal ownership. Under the proposal, the municipality would transfer parts 4, 5, and 6, which are the blue ones on the drawing, in exchange for receiving parts 1, 3, and 7, which are the red, and the arrangement results in benefits for both parties. For the municipality, the exchange secures the existing alignment of the North Perth Trail and provides improved access to the southeast major overland flow route, which is formerly the number 1 drain, which will ensure adequate access for inspection and future maintenance of that drain. For Dunnigans, the transfer of parts 4, 5, and 6 will allow for a more efficient and practical lot layout that will better support future site design and development opportunities. If I press the arrow, will it go to the next one? I have a future configuration. So if we go ahead and do the land exchange, the blue property will be North Perth, and then the red will be owned by Dunnigan's Haulage. As you can see, it's more of a regular configuration instead of like a weird jagged parcel. In conclusion, staff recommends that council declares parts 4, 5, and 6 on the draft reference plan surplus for disposal in order to proceed with the proposed land exchange. I also have included an aerial photo just so you can kind of see where this is in town. So there's Reserve on the right-hand side. The Kinsman Trail goes up the back, which was that long, skinny portion. Davidson's at the top, and then it's also just near Wallace South. I'd be happy to answer any questions if anyone has any.
Great, thank you, Ms. Mayhew. Colleagues, any questions or first comments on this matter? Councillor Rothwell.
Thanks very much, Mayor Todd, and thanks for your presentation. Can we just go back to the photo before? I think, and it's the area shown in blue on that north side. Is that heading on to, is it a stormwater management area or a drainage corridor that is, again, the land area on the north side of that?
That long, skinny one there?
No.
The wee tiny one?
I know, if you will, on the left side or the south, that's for the trail, but I'm just wondering on the other side, on the right side or the north, what's that?
I think Matt's going to answer this one.
Yeah.
Mr. Rob?
Through the mayor, simple answer is yes. So in working this out so that it's an equal land transfer, we want to make sure that we're maintaining a sufficient right-of-way on both sides of the storm channels. So In doing so, I think we're about 5.5 meters on that side. So that's why you see we are still having some remnant parcels that come back to North Perth. That's just making sure that we have at least 5+ meters to get equipment should we ever need to maintain or clean out that drainage channel.
Good. Thank you very much.
Okay, anyone else? Seeing none, I have a resolution for our consideration as follows. That the Council of the Municipality of North Perth declares surplus for disposal property described as parts 4, 5, and 6 on the draft reference plan of survey prepared by MTE Ontario Land Surveyors Limited, file number 62938 underscore 002 R1. In order to create one parcel known as part of Lot 37 Concession 1, part of Corporation Lot 18, Register Plan 194, designated as Part 2 on the draft reference plan, Municipality of North Perth being part of PIN 53022-0073 LT LRO number 44. I'm reading the phone book again. Colleagues, can I call for a mover? Moved by Councillor Rothwell, seconded by Councillor Richardson. Thank you. Councillor Johnston is curbing his desire to have me read that one more time. Any discussion or debate? Seeing none, let's have that vote. And that is carried. Thank you. Item 9.3.2 brings an updated draft of the servicing master plan, formally reviewed for us by consultants and with our staff in September, back to our table for consideration and, if suitable, adoption. Matt Ropp, our Manager of Operations, is with us to support our understanding and deliberation. Welcome, Mr. Ropp.
Good evening, Mayor Kasenberg, members of council, and members of the public. On September 22nd, 2025, staff along with BM Ross presented the draft servicing master plan for Listowel and Atwood that identified future water, wastewater, and stormwater needs. The final draft was posted on September 24th. It was also advertised in Independent Plus on October 2nd and 9th. It was sent to the open house attendees as well as Indigenous communities for a mandatory 30-day review. We received one comment from the Ministry of Citizenship and Multiculturalism on October 27th, the last day of the review period. Their requests were integrated into the plan with no change or recommendations resulting from their comments. After fulfilling all the requirements of the Municipal Class EA, an exciting, at least for the Operations Department, exciting final step has staff before you tonight requesting adoption of the servicing master plan dated November 7th, 2025, in the direction to staff to post the final report on the municipality's website. Be happy to take any questions.
You know that humor in this chamber is supposed to be reserved by myself and
I'm
my
picking
colleagues,
up on your cues.
right? Right, okay. Colleagues, questions and first comments? Anyone with anything further? All right, it was a big long read. I have a resolution for our consideration as follows: that the Council of the Municipality of North Perth adopts the servicing master plan for Listowel and Atwood dated November 7th, 2025, and directs staff to post the final version on the Municipality of North Perth's website. Moved by Deputy Mayor Kellum, seconded by Councillor Anstead. Any discussion or debate? Seeing none, let's have that vote. And that is carried. Thank you so much, Mr. Ropp. That is a big achievement, actually, for us to adopt and endorse this plan. Okay, let's turn to reports and requested actions from the CAO's department. It's item 9.4. It's item 9.4.1. North Perth CAO Chris Snell brings to Council's attention a matter of proposed memorandum of understanding, a form of contract with various healthcare operations in our community related to healthcare professional recruitment. Mr. Snell, please.
Good evening, Council. As Council is aware, we are an active member of the Healthcare Recruitment Committee. That committee has been working on a memorandum of understanding to establish a shared framework between the partners, including Listowel Memorial Hospital, Listowel Memorial Hospital Foundation, the Listowel Wingham Area Family Health Team, and the Municipality of North Perth to support the recruitment and retention of physicians within the community. So we have looked at the draft MOU, and certainly between staff and our solicitor, we have raised some concerns that council to bring to council's attention. And at this time, we're just wanting to put forth too is even though we've been an active member, it's an appropriate time when the municipality should become a formal signatory to an MOU or instead just act as a external funding partner. The comments and concerns brought forward is funding should only be guaranteed after March 31st of every year upon the official annual adoption of the municipal budget. The hospital responds for initiating the request to invoice the municipality. Annual funding should be conditional upon a budget adoption. Any unspent funds should be returned to the municipality or carried forward to the next fiscal year with appropriate reporting and accountability measures. The MOU should explicitly state no employment relationship between the recruitment officer and the municipality. There should be a definition or a term to the agreement. Our solicitor is suggesting 3 years. Any party should be able to withdraw within 6 months instead of the annual 1 year that's mentioned in the current draft. It should clearly outline the type and amount of municipal contributions and what their purpose is for. And then some changes on the identification clauses and clause saying that the language and activities does not restrict council's decision-making authority to carry out its statutory responsibilities. At this time, staff are seeking council's feedback and direction on the proposed MOU, and they're suggesting that we renegotiate some of the terms with the Municipal Physician Recruitment Committee based on our feedback from staff and the solicitor.
Thank you, Mr. Snell. Comments, questions? Councillor Andres.
Thank you through you, Mayor Kasenberg. Municipal funding for local health care seems to be a necessary component now to ensure that our healthcare system locally is getting the funds it needs. But I'm not sure if the general public is really aware of this. So I'm wondering if there is going to be recognition, or maybe perhaps was mentioned already, or in the works already, but is there going to be some kind of plaque or I don't know, some recognition that the municipality is contributing to our local health care on a regular basis so that the general public is aware that, we are investing our local tax dollars into healthcare here, which really should be provincial responsibility. But, we see that as important, and we are making those investments locally. So it would just be my hope that somehow there could be some form of recognition and acknowledgement that the public could see regularly. Thanks.
CEO Snell.
That's certainly not part of the current agreement, but that's something we could take back to on the table.
Thank you.
Thank you. I would like to see that. Thank you.
Deputy Mayor Kellum.
Yes, thank you through your Mayor Kasenberg. Thank you, CEO Snell, for it. Can you go to the part again about funds not being used, return back to the municipality? Didn't clarify that with me, please.
Sorry.
The funds that they do not use, be refunded back to the municipality?
Or a report back to us saying what funds weren't used and sort of how they'll be used in the future and accounted for. It's just basically being more transparent if the funds aren't used. Just almost keeping a running total. If they're not returned, we should at least know how much they have and what they're using it for. So it's fully transparent to everyone.
Absolutely, I agree with that. Thank you.
I'll weigh in. I like Councillor Andreessen, share the concern that healthcare, including the physician and health nurse practitioners, other healthcare professionals, largely is a provincial responsibility. And I have been uncomfortable at the creep that we've seen over time in terms of the engagement of the municipality in this swim lane. I really want to continue to send the message, as we've sent it, that the province needs to stay in its swim lane and do its part. in resolving some of the challenges of physician recruitment in particular. I do find it very strange, and I'll offer a specific comment suggestion to this, and that those parties who are receiving a grant from us want us to sign a contract. Like, to me, that's just a very strange kind of arrangement. If anything, we're the ones who should be proposing the contract, and we should also. And here's my thought about a condition that perhaps staff should take up with the hospital and the other partners. There should be some performance measures that are evaluated so that we're getting value for money here. We would expect this, and it's expected of us certainly by the province. Many of the grant programs that present themselves to us that we apply to. The province puts us through all kinds of paperwork and expectations of fulfilling various targets and measures. Mr. Ropp is nodding his head vigorously. Thank you. Um, and we would certainly expect that kind of performance from a charitable organization, for example, that we would give a grant to, or if we were to invest money in tree planting or any of that kind of thing. So I find myself quite compelled by the importance, if we're going to enter into an agreement with these parties, that they're going to be accountable for the funds that they've given us. They're going to have to indicate what measures, one, they intend to hit, and two, show performance against those measures so that we can reasonably evaluate renewal and renewability of the funding. So it does, I'm a little irritable about this one, but anyway, I think that's an improvement that I would recommend to staff, and I am in support of further discussion and negotiation around this matter. But it still seems like a very weird world where the one receiving the money is trying to dictate the terms. Councillor Johnston.
And I agree with you, Mr. Mayor, that it just seems weird. And I wonder if this is the time for us to step back from this. I agree with physician recruitment and the money we give. I don't have a problem. But does this almost signify that we're going to give that much money every year? And what if in 3 years from now, or whenever they're, in 2 years, we have a real budget constraint that we need to step that 50 or 65,000 back to 10,000? Is that going to put us in a bad way with the MOU here? So that what bothers me a little bit as well. And I believe we have a representative at the table, right, Deputy Mayor? And I don't have a problem supporting physician recruitment. I'm just not so sure that this is the way to go. Thank you.
Councillor Richardson.
Thank you, Mayor Kasenberg. I have to agree with that. I also agree that there should be some levels of benchmarking that would come back, as to say, at least we've been doing this. It would be very difficult to try and ascertain unless you say that you actually recruited a doctor, but to say that you're going forth in these efforts and the money being put forward to that. And I also have to agree that if in the future we happen to have some budgetary restraints, we have the means within that contract to be able to say, hey, this year is going to be incredibly challenging for all of the ratepayers in North Perth, that we need to scale this back a little bit, or at least some wording is such as to can go up to the amount of, instead of just a definitive amount. Thanks.
Thank you. Anyone else? Councillor Andreessen.
There is a clause in the agreement that says that the MOU should, any party should be permitted to withdraw from the MOU with 6 months written notice. So does that cover it, CEO Snell?
I guess it depends on when we started budget deliberations and when they expect the money. So I think the clause recommended by the solicitor and staff would be that the annual funding has to be conditional upon budget adoption by council. And therefore it could vary. I know as of today we're committed to our 2026 budget, and it is difficult to commit future councils to third party commitments when we still don't know what our own financial analyst might be in 2027, 2028.
Thank you. Anyone else? Councillor Roth.
Thanks, Mayor Todd. Thanks, Chris, for the report. I think the challenge in my mind is on the fiscal side when you look at page 447 or agenda package. So North Perth, we're saying 65,000, and then the balance between the Listowel Memorial Hospital Foundation at 20, Listowel Wingham, an area family health team at 4,000, and then Listowel Wingham Hospitals Alliance at 33,600 in kind regarding housing. North Perth is at 65,000, and the balance is 57,600. So there's more coming in from North Perth than within the whole of the Listowel Wingham area. And I don't want to get too carried away with boundaries, but frankly, when North Perth is putting in $65,000 on here, I think we better have a lot more say than only passing comment in terms of where the effort is in terms of on the Listowel side as opposed to the Wingham side. I mean, we're great neighbors and so on, but the reality is the local municipality for Wingham does not have any dollars on the table here, which is problematic in my view. Thank you.
Thanks. Go ahead, CAO Snell.
Maybe Deputy Mayor Killam could help me on this, but I believe there's a separate agreement that's being signed by the northern Huron County municipalities, but I'm not sure of the status of where that's at.
Or whether the provisions are similar.
That's
and as encumbering. In fact, I don't know any of that. Right? It's a bit of a mystery to me. So I find myself uncomfortable with this. You know, I'll offer one more comment here. The Premier has indicated that by 2029, he expects every Ontarian who wants a healthcare professional, a primary healthcare professional, to be attached to one. And I personally think that he intends to live up to that commitment, and I think we need to hold him to it, which in the broad scheme of things could certainly affect how much we invest in the very near future, to Councillor Richardson's point. So I find myself very, very wary about this one, and like I said, struggle with what feels like a strange universe here, where the tail is wagging the dog. That's what it feels like. Anyone else? Okay, let's consider the resolution. Staff has proposed more attention to be paid to this, and I think we've had a chance to air our concerns. So let's consider the resolution that the Council of the Municipality of North Perth refers the Listowel Physician Recruitment Committee Memorandum of Understanding back to staff for further review and discussion with the partner organizations. And I'm going to trust that staff has heard the comments of Council tonight and will reflect those in the proposed discussions and review process. Fair? CAO Snell, that's fair. Moved by Councillor Rothwell, seconded by Councillor Andreessen. Thank you. Any further discussion or debate? Seeing none, all those, let's have the vote. All those come to the computer. And that is carried. Thank you. Thank you, colleagues. This moves us to item 9.4.2, time for the exodus again of those who declared their pecuniary interest or potential interests. And I'm going to surrender the chair to Councillor Duncan.
Please note for the minutes that all the councillors who have declared a conflict have left the chambers. And we'll move along to 9.4.2, transfer Perth Meadows to United Housing. Chris, you're going to speak to this?
Thank you, Council. I'm certainly not going to go through the first part of the report because I believe it was really covered when Mr. Bert Johnson was at the podium. I did look up in the meantime, though the resolution was passed on February 10th, 2014 in open council, for the record. I'm requesting that staff prepare the RFP for the management or disposition of the property. So Perth Meadows has always been rooted in community. The original Perth Adult Life Care Residence Initiative reflected a long desire to provide affordable and attainable housing for seniors, a vision that remains relevant today. And transferring Perth Meadows to United Housing ensures that this community-focused legacy continues. Transferring this asset to a community-focused housing provider will promote greater efficiency, cost effectiveness, and long-term sustainability while advancing the municipality's commitment to affordable and attainable housing options. As council will recall, we back when we originally assumed control of Perth Meadows, it was to save the asset. It was originally run by a not-for-profit community-based organization. This would be a service or a core service that most lower tier, or almost no lower tier municipalities operate, being in the housing business. So, to say the least, it's not our expertise, and sometimes is not something that we even can rely on other lower tier municipalities for guidance and support on because they don't operate housing units of any sort. So, in that belief, we do really believe that a community-based housing provider with a focus on housing really is the best for the long term of this asset. As council is aware, this is taken on without. This was taken on, and we did do a lot of due diligence. As said, the discussions have been ongoing for over a year and a half to determine if United Housing and the municipality were good partners. The day-to-day life at Perth Meadows will remain unchanged. The leases are legal agreements between us or previous to that, the previous not-for-profit board, they are transferable and they are legally binding no matter who owns the property. So the leases are guaranteed. They go with the asset. The funds that has been invested by the leaseholders also goes with the asset. As council is aware, we have worked closely with United Way to make sure that the continued operations really represent what Perth Meadows is today, and we've actually incorporated certain conditions into the purchase and sale agreement. The municipality will maintain a right of first refusal for up to 15 years if United Housing ever wishes to divest themselves of the property. And there's a commitment in the agreement that United Housing will maintain a similar framework ensuring affordable and sustainable housing for seniors. So again, the financial contributions, all the life lease and suite deposits will be transferred as part of the negotiations. The non-cash transfer on our aspect is we will remove the $6.7 million from our assets and will be transferred over to the United Housing, and they will be responsible to pay the outstanding balance on the Infrastructure Ontario loan. That's really the summation of my report. It was prepared by Ashton mostly, and I want to thank all the staff that have helped put together this and been involved in negotiations looking at this asset. I think the long-term goal of all of North Perth staff and I believe council is to make sure this asset remains an attainable and affordable housing unit for seniors going into the future.
Okay, thank you, Chris. Council, questions, comments? Dave?
Thank you, Chair Duncan. So Chris, it's right in the transfer conditions that it is to be maintained ongoing affordability and stability for seniors. That's right in the conditions of transfer.
Yes.
Thank you.
Matt?
Thank you, through you, Chair Duncan. Obviously, there's been a lot of going back and forth with this. On one hand, I don't have a problem with how things are proposed, but on the other, I do feel that it is necessary for all of the issues that have been brought forward by the residents tonight in writing should be recalled back to the actual residents themselves, like even what was been mentioned here by yourself, Chris, and the 55 plus and how their finances are secured, what their finances are going to be, their security going forward. And there's a mention made about kids in the building and this and the ongoing operational. I think fair is fair is to be able to provide that sort of updated information that was only provided at one meeting and verbally here. So, in my opinion, I think it's fair to be able to defer this until the next meeting and be able to provide this information and to give the residents of Perth Meadows a little bit of structure and understanding that everything in their power has been done to do to protect them and the investments in their security and their home. So
Okay.
I would put forward a deferral for this motion.
You'll make a motion.
I'll make a motion for that.
Okay, I'll get Councillor Andreessen's comments first.
Thank you through you, the chair. It is one thing that is really important to me is that the fact that these are homes of people in our community, and a home is very near and dear to everyone's heart. And I think that getting a little bit more information for these residents might be helpful, and to seek a better understanding of what's proposed, and to help everyone feel a little bit more comfortable in moving forward. And I think that um, a deferral at this time would be important for their peace of mind, and I think it might help with moving things forward a little bit better. So I would support that deferral motion. Thank you.
You'd be willing to second that then, Leanne?
Yes, I would.
Any other? Neil?
Thanks, Chair Duncan, through you, and thanks, CO Snell, for your report. And I know a lot of work went into this, and it certainly was, just to echo what Councillor Richardson and Councillor Andreessen have said this evening, it certainly was helpful to hear from the residents themselves this evening. And I appreciate that you did reach out via email as well. Now, one thing we're committed to on council is being open and transparent. That's in everything we do. And I would certainly support the deferral at this time as well, just to make sure that everyone's aware of all the steps that we're taking and everything that's going to happen going forward. So I would support this as well. Thank you.
Okay. Yeah, I just want to make a couple comments. I did receive the emails and a few phone calls over the weekend and this morning as well about this, and I know that change is definitely uncomfortable. As humans, we don't like it. There's no doubt about that, especially when it comes to where we live in our house and our investments. I want to make sure that the people that reside at Perth Meadows understand that the short term, how do I word that? The short period of time in which the meeting was called to let everyone know was a matter of protection of confidentiality. We as council did not want this to be floating around in the rumor mill before the residents were informed that this was the intentions. It was definitely not to be malicious in any way or hide anything from the residents there. And I too am in support of the deferral for a week or 2 weeks till our next meeting so that all the issues can be sorted out amongst the residents. Their questions can be answered by our staff in United Housing, and we'll move forward from there. So I've got a motion on the floor to defer. I'll call for the vote. Thank you. It looks like that motion. Manuel vote. Oh, I didn't see. There you're up there now. Okay. Okay. That motion is carried. This item will be deferred until the next meeting.
Thank you. Thank you, Council.
I'll now turn the chair back over to the mayor.
Okay. Thanks to Councillor Duncan for his service in these matters. Let's turn to item 10 next. Does any member of council wish to ask for a report from staff or of one of our committees? I think Councillor Johnston, I think you were there. Okay. All right. So not Councillor Johnston. Anyone else wishing to make a request for a report? Okay, not seeing any. So we're moving on to item 11. We have received one item of correspondence beyond those already shared in the consent agenda for council's disposition. In item 11.1, the North Perth Chamber of Commerce has submitted a request for various road closures related to the upcoming Santa Claus Parade on November 29th. I have a resolution that's prepared for us to support that somewhere as follows. That the Council of the Municipality of North Perth approves the road closure request from the North Perth Chamber of Commerce for the 2025 Christmas Parade to be held on Saturday, November 29th at 5 p.m. for the following route: Q on Maitland Avenue South, begin at Main Street East at Maitland, west on Main Street to Albert Avenue North, north on Albert to Binning Street West, west on Binning Street to the Steve Kerr Memorial Complex, and that North Perth Public Works, Fire, OPP, and Perth County EMS be advised of the event. Can I call for a mover? Councillor Anston. Thank you. Councillor Duncan will be our seconder. Any discussion or debate? Seeing none, let's have that vote. Councillor Rothwell records a manual in favor vote. And we're waiting on one. Councillor Nordum? And that is carried. Thank you. At this point, we're going to turn to consideration of bylaws that have been recommended to us for action. Councillor Duncan advises that we are removing one of the bylaws from this resolution, which will also change our declarations potentially of pecuniary interest, but that will all get cleaned up as we figure it out. I have. Okay, yes, I do. Thank you. Thank you. Good call. So the clerk has pointed out to me we have a revised resolution as follows: that the following bylaws are hereby passed. 110-2025 being a bylaw to authorize the signing of an agreement with the Maitland Valley Conservation Authority. 117-2025 being a bylaw to authorize the signing of a land exchange agreement with Dunnigan's Haulage Limited. And 118-2025 being a bylaw to provide winter maintenance guidelines. Can I call for a mover? Moved by Councillor Richardson, seconded by Councillor Anstiff. Thank you. Any discussion or debate? Seeing none, let's have that vote. And that is carried. That brings us to item 13 on our agenda. Let's have a look at this. Does any councillor wish leave to give notice of motion tonight? I'm not seeing any expression of interest there. Let's turn to item 14 on our agenda. Are there any announcements that would be of benefit to our community or that reflect well on North Perth at this time? Those in the chamber certainly may raise their hands if they'd like to make an announcement. Anyone? Okay, not seeing that. Turn to item 15. We have no matters for consideration in a closed session meeting of council. That means with regards to item 16, there is nothing to report back to the community since we did not hold a closed session. And now, I guess we should still exit probably. The three who've declared pecuniary interest still need to exit the chamber. So we're going to turn this over to Councillor Duncan. I'll be back for my wrap up. Councillor Duncan.
All right. Council has a mandate good practice action at the end of its meeting agenda to confirm all of its actions and business of its meeting through what is called the confirmatory bylaw. Bylaw 119, 2025. Moved by Councillor Richardson, seconded by Councillor Nerdum. So the vote on that. That's carried. Turn the chair back over to the mayor.
All right, colleagues, for our bylaws that touch on provincial priorities considered and passed at tonight's meeting, I am in support and will not execute a veto. This information is provided and will be provided to the clerk as part of my required duties as mayor. Colleagues, we have completed the deliberation and taken action on the business that came before us tonight. It is thus appropriate for us to consider a motion for adjournment, and I have that here. I'm going to turn to it. As follows, the council meeting adjourns at 9:52 p.m. to meet again for general council business on Monday, December 1st, 2025 at 7 p.m. We need people around this table to feel better by that date, apparently, because everyone's coughing now. It's all melting down. Moved by Councillor Andreessen, seconded by Councillor Rothwell. It's not a debatable motion. Let's have that vote. And that is carried. I think we need to order in some chicken noodle soup for a few people, but otherwise we are